know this has happened to you because you told me so. So let's talk about your rights, your remedies. So let's get started.
In a situation like plaintiff's, she could sue under the ERISA Act. The acronym stands for Employee Retirement Income Security Act. ERISA applies to most private employee benefit plans and does not apply to government employee benefit plans. So let's look at ERISA. Section 510, 29 U.S.C., Section 1140 of the Employee Retirement Income Security Act, ERISA, strictly prohibits employers from discharging, fining, suspending, or discriminating against a participant for exercising their right to a benefit or to prevent them from attaining benefits. ERISA covers retirement, employee welfare benefit plans, which include health insurance, disability, life insurance, disability plans, private plans, except under the safe harbor rule. To succeed in an interference or retaliation claim, you generally do not need to prove that the employer's sole purpose was to deny benefits, but rather that it was a motivating factor in the adverse employment action. Successful plaintiffs can recover wrongfully denied benefits, attorney fees, and sometimes equitable relief, such as restitution of profits made by the employer/insurer by improperly holding the funds. Now remember, the plaintiff is deemed disabled. She has PTSD and agitated depression. And let's assume that her PTSD and her agitated depression constitutes a legal mental illness. Will she be able to get the statute told? Because ERISA Section 510 does not contain an explicit federal statute of limitations, federal courts apply the most analogous state law deadline, usually 2 to 3 years for wrongful termination or retaliatory discharge. Some jurisdictions toll the clock while you are strictly required to go through internal company grievance or appeal procedures. That's why I always reiterate, even when you're dealing with a federal statute, you want to look at the local statutes and the rules. And some of you might be wondering, well, how is it that a federal statute can regulate private plans? And that's a good question. Congress allowed this to address widespread fraud, mismanagement, and other things that were happening in the private sector pensions. Okay? This can be told under rare federal common law doctrines if you can prove you were actively misled by your employer about the reason for your termination, or if you were extraordinarily prevented from filing, example, because of severe mental incapacitation. Because ERISA Section 510 does not contain its own built-in statute of limitations, federal courts borrow the most closely matched state law timeline, typically wrongful termination or retaliatory discharge. Along with borrowing the state's timeline, federal courts also borrow that state's rule for equitable tolling and mental incompetence.
So the question is, would the plaintiff successfully get the statute told? So let's assume that these facts are true. That after she was terminated, she immediately went into a deep depression and slept for 3 years. Okay? She awakens and discovers this. Will she be in a better position to toll the statute based on what we discussed? What do you think?
I trust this has been helpful to you. And until next time, take care of yourself and take care of your mental health.